The legal team for Luigi Mangione, the man accused of murdering United Healthcare CEO Brian Thompson, is seeking dismissal of his New York State murder case, arguing double jeopardy as he faces a concurrent federal trial. Criminal defense attorney Brian Claypool on how this all plays out. Brian, great to see you.
Hey, Mike, great seeing you as well. Thanks for having me.
What's your assessment of that argument from Mangione's team?
Yeah, I think it's dead on arrival. The U.S. Supreme Court has already ruled on this issue, Mike, and they have come down categorically that it's not double jeopardy if you're charged concurrently with a state crime and a federal crime. Remember, the federal crime is different than the state court crime, and that's not considered double jeopardy. Do you remember the case with Derek Chauvin? Remember the police officer in the George Floyd case?
Yeah.
He faced both state and federal trials. So this argument about double jeopardy is just simply not going to fly.
You're a criminal defense attorney. Is it a sign of desperation?
I don't think it's a sign of desperation. I really don't. If I was representing Mangione, I might give it a try, because I think the optics are that it really is double jeopardy. I mean, if you think about it, you technically are going through potentially two trials for the same crime. So when I first looked at this issue a while back, I thought, maybe there is some traction on this argument. But once I looked at the U.S. Supreme Court case, there's a solid precedent on this. These are two different crimes, two different jurisdictions, Mike. That's really what this is about. It's about a state court and a federal court, and you have a right to prosecute in both of those courts. So I think his attorneys are doing what they should do.
Okay, I'm sure both cases will be very high profile. We'll follow the developments. I want to ask you about another case here in New York, this time in Syracuse. 11 high school lacrosse players are being charged with unlawful imprisonment in the second degree after allegedly hazing 5 younger teammates. The students are accused of staging an armed kidnapping. They turned themselves in earlier this week. Do misdemeanor charges go far enough?
Hey, Mike, this is really irresponsible of the prosecutor. Why do I say that? Because there was a gun and a knife used. I mean, these young boys were transported in a car, blindfolded. They didn't even know where they were going. One of the boys was thrown in the trunk of a car, and then 2 other guys shot with masks, one with the gun, one with the knife. It is a Class D felony in New York, Mike. It's a second-degree assault if you use a weapon when you have abducted somebody like this. That carries, Mike, a prison term of 2 to 5 years, a minimum of 2 years. So what message are you sending young adults if you simply say, hey, turn yourself in and we won't charge you for kidnapping or second-degree assault. You'll get misdemeanor. You'll get no jail time. You'll be prosecuted as a juvenile. What's up with that? Why hasn't there been a deep dive into the investigation? Why haven't these victims been interviewed? Why haven't their families been consulted before the prosecutor makes decisions like this? It's flat out irresponsible.
Brian, you're a criminal defense attorney. How would you defend these guys?
Well, yeah, the flip side of that is, hey, these are young guys. It was a joke. It was a prank. And we never really intended to harm anybody. Because one of the elements to get a more serious charge, Mike, is you had to have an intent to harm some of these victims. So they're just going to try to call it a tradition, and that, look, these guys they're too young, really, maturity-wise, to really form the intent to commit a serious crime like that. So that's going to be their argument. Sounds like it already has traction with this prosecutor.
Brian Claypool, thanks so much.